Ali Hadi bin Zainal Hadi is interested to purchase a unit of double-story semi-detached house in Taman Sepang Perdana from Angkasa Development Sdn Bhd, who is the developer. Upon attending the launching at the developer's site office, Ali Hadi decided to buy Lot 334 at the purchase price of 730,000 ringgit. The individual title to Lot 334 has been issued by the state authority, and the same is held under GM 656 Lot 334, Mukim and District of Sepang Negeri Selangor. The individual title is currently charged to Singa Malaya Bank, SMB, as a security for the loan granted by SMB to the developer. Ali Hadi was informed by the developer that A. He has to pay 10% of the purchase price upon signing of the sale and purchase agreement, and B. The estimated amount of the outstanding loan due to SMB in respect of Lot 334 is 250,000 ringgit. Your firm was appointed by the developer to handle the sale transaction for Lot 334. Ali Hadi notified you that he will be applying for a loan from Maju Trust Bank, MTB, for a sum of 650,000 ringgit to part finance the purchase of Lot 334 from the developer. Ali Hadi wants to know the conveyancing procedures involved until the title is registered in his name and full disbursement of the loan by MTB. Advice Ali Hadi.
Hello, Miss Lawyer. So I want to ask your opinion. Why I have to pay 10% of the purchase price upon signing of a sale and purchase agreement?
Ali, as the buyer, you are required to pay 10% of the purchase price upon signing of the sale and purchase agreement. This is also known as a down payment, which is a mandatory lump sum payment paid up front for the purchase of a property, whether from a developer or a seller. In this situation, Ali, you acquired the property straight from the developer, Angkasa Development Sdn Bhd. A down payment is typically made by a buyer to a seller or a developer to secure a sale. Buyers are required to pay a minimum 10% of the property's purchase price. In this context, we refer to minimum rates because there is no specified upper limit. Some home buyers pay more upfront to reduce their overall home loan, thus reducing the monthly payment amount and total home loan repayment schedule. If one unit of a double-story semi-detached house in Taman Sepang Perdana costs 730,000 ringgit, Ali, you will be required to pay at least 73,000 ringgit in advance. You can pay the remaining balance through a home loan or any other similar loan. Ali, you have previously notified us that you will be applying for a loan from Maju Trust Bank, right? The first part of a down payment is usually paid as part of an earnest deposit. In most instances, this is a non-refundable 2% payment to demonstrate that a buyer is really serious about purchasing the property. The earnest deposit is paid as part of a letter of offer or offer to purchase. The terms of this agreement often stipulate that the 2% payment cannot be refunded in the event that an agreed deal is not completed. The earnest deposit of 2% counts towards the total down payment of 10% on a property. Therefore, if Ali has paid 2% earnest deposit, only the remaining 8% balance will be due at the signing of the SPA. Sales and Purchase Agreement, or SPA, is a contract for the purchase of new, uncompleted properties. It is a crucial instrument that protects you, Ali, as the buyer by preventing the developer, Angkasa Development, from modifying the terms and conditions to their benefit. Any modifications to the terms of the agreements are void and unenforceable. The SPA is the formal and final contract between the developer and Ali. Once the SPA is confirmed, the remaining amount of the down payment is to be paid fully on the day of the signing of the SPA. In Malaysia, the Housing Development Act requires all housing developers who sell off residential properties to follow a standard SPA format. As specified in Regulation 11 of the Housing Development Control and Licensing Rules 1989, the developer and buyer will use one of the SPAs prescribed in Schedules G, H, I, and J. The schedules will specify the developers and the buyer's responsibilities, such as when Angkasa Development should deliver the property and when you, Ali Hadi, should make the payment. The issuance of these schedules are based on the type of property as well as the method of purchase. In your situation, Ali, the relevant schedule that has been issued is Schedule G. This schedule is used for the selling and purchase of landed residential property under the Sell Then Build STB system, which is sold under individual titles, usually reserved for landed properties such as your double-story semi-detached house. When a house is sold before it is built, it is referred to as the STB system. This enables developers to sell houses using brochures and skilled models before building them. This can be seen when Ali had decided to buy lot 334 while he was attending the launching at Angkasa Development's site office. STB's system allows a developer to collect money from prospective homebuyers while the houses are still being built in accordance with the third schedule. Therefore, the funds raised from you, Ali, can be used to finance the construction of your house. Your individual title is currently charged to Singa Malaya Bank SMB as a security for the loan granted by SMB to Angkasa Development, but you have nothing to worry about because it is actually very common for banks that had financed the purchase of a property to keep these titles. Ali Hadi, in the event that you breach the SPA, the money paid to Angkasa Development will be forfeited. As a result, the developer gets to keep that 10% down payment. The seller or developer is not required to prove any damage before forfeiting the deposit because the buyer's failure to pay the purchase price is a fundamental breach. This can be seen in the case of Morelos Sendirian Berhad and Jats International Sendirian Berhad, where it was held that the effect in law of the contractual obligation to pay deposit is to vest an indubitable right in the vendor to receive the deposit upon the contract coming to existence, notwithstanding subsequent termination. Likewise, in Lingi Plantation Limited and Jagatisan, Lord Hilsham referred to Howe & Smith, where Fry LJ said, it, referring to the deposit, is not merely part payment, but is then also an earnest to bind the bargain so entered into, and creates by fear of its forfeiture a motive in the payer to perform the rest of the contract. So Ali, you have to pay that 10% purchase price upon signing of the sale and purchase agreement.
I see. So thank you so much, Miss Adlyn. So I have to pay 10% of the purchase price upon signing of a sale and purchase agreement, right? Okay, I understand right now. I think right now I will make Miss Syahaneem or Miss Insyirah, right, for the loan application that I have issue about the loan application. Another issue of registration procedures because I really know about the registration procedures. Thank you so much, Miss Adlyn. Okay, I think I have a little problem regarding my loan application with Maju Terus Bank. So I don't really understand about the process because I want to apply for full loan, and sometimes he said that I'm not gonna get full loan that I want. So maybe you can explain to me a little bit.
To begin, as a borrower, you will apply for a loan once you have received the stamp sale and purchase agreement. When the loan is approved, MTB, the bank, will send a letter of offer to you which you will accept. However, loans are not always approved as applied by the borrower. The borrower applied for a loan of 90% of the purchase price, but the loan approved is only 80% of the purchase price. The difference between the balance of the purchase price and the loan approved to be settled by the borrower is known as a differential sum. Then, MTB, the bank, will appoint a solicitor to act on their behalf in preparing all necessary loan agreements. The solicitor must also ensure that the legal charge is registered in MTB's favor and that the loan amount is released within the time frame stipulated in the sale and purchase agreement. The next step is to conduct a title search on the property, which involves examining public records at the land registry to determine who the registered proprietor of lot 334 is and whether the property is subject to any encumbrances, caveats, or future land acquisition or restriction and interest. Angkasa Development Sdn Bhd is the registered proprietor of lot 334, and lot 334 is currently charged to Singa Malaya Bank Berhad. Following that, a bankruptcy search or winding up and company searches will be conducted. The search is carried out at the Insolvency Department of Malaysia to determine the legal status of both the vendor and the purchaser or borrower. The search can be done online or manually for a fee of 12 ringgit per name search. If the purchaser is bankrupt, he is not allowed to enter into a contract of sale and cannot buy any property. Hence, a bankruptcy search will be conducted on you, as well as a winding up and company search on the vendor, Angkasa Development Sdn Bhd. The very next step is the solicitor will prepare 4 copies of the loan agreement, 4 copies of the charge documents, and a copy of your letter of undertaking. The letter will be forwarded to the bank once the borrower has signed it. A situation in which the charge could not be registered is when later on the land office discovers that the issue document of title was a forgery. For the above reason, the bank is depending on this undertaking letter to recover the loan from the borrower. The following procedure requires the execution and attestation of security documents by both parties. The purchaser and purchaser's bank must conduct the attestation in Form 19B since MTB is a company. The execution shall be operated in a manner authorized by MTB's constitution or by affixing MTB's company seal and a statement signed by their 2 directors. to the effect that the seal was affixed in their presence. The next process is to stamp the document and pay the stamp duty on charge. Only one instrument must be stamped with duty ad valorem. The principal document, typically the original loan agreement, must be stamped with ad valorem stamp duty. The remaining 3 copies are to be stamped with nominal duty, which costs 10 ringgit each. The formula for stamp duty ad valorem on charge is 5 ringgit for every 1,000 ringgit of loan facility with regards to other documents such as charge documents like subsidiary documents and its copies. Nominal stamp duty must be paid. The short formula for calculating stamp duty on charge is to multiply the loan amount by 0.5%, as well as nominal stamp duty of a total of 70 ringgit for the other 3 copies of the principal document, subsidiary document, and its 3 copies. The stamp certificate will be issued once the stamp duty has been paid. The following step is registration of charge, which occurs at the land office. The process of registering a charge entails presenting the charge document in both its original and duplicate form, attached together with the original title, stamp certificate, consent to charge, where applicable, and other documents such as quit rent, assessment, which is cukai pintu, parties' identification cards, as well as registration fees. The process of registration involves a sign and seal by the registrar or entering of a memorial on the registered document of title and on the issue document of title. Subsequently, the loan will then be released by the bank. The solicitor will advise the bank to release the loan upon presentation of the charge document. After 1 to 2 months, the solicitor will collect the original title and duplicate charge and deliver it to the bank as security until the loan is paid off. If, for example, the borrower fails to make payments on the loan, these 2 documents will be used in the foreclosure proceeding. Following loan settlement, the charge will be discharged through the filing of Form 16N. The registrar will cancel the memorial relating to the charge to be discharged on both the register document of title and the issue document of title. The registrar will then endorse on the original and duplicate charges that the charge has been discharged. The proprietor will then be in possession of the original title with the property free of all encumbrances.
Hello, Miss Syahaneem, right? Oh, okay. I think I have a little problem. So I think I don't really understand about the process.
In regards to Ali Hadi's question of the conveyancing procedure of the Lot 334 purchase, so since the purchase is direct from the developer, hence it is a type of transfer by way of a regulated contract of sale under the HDA. So this type, it governs under the law of contract, ensuring that all valid contract elements are fulfilled. So it involves the developer, the registered proprietor whose income generates from developing and selling properties, and the purchaser who is interested in owning that property. So the HDA is the major provisions governing the contract, as well as other regulations, which includes but not limited to, such as Housing Development Control and Licensing Regulations, HDR. So, Lot 334 is a real property, simply because it can be owned by a person and built upon land and immovable. And housing projects governed by the HDA for the protection of purchasers' interests include real property developments. So, Ali Hadi's purchase of Lot 334 is a sale that is within the ambit of HDA, which relates to the process of transfer of real property directly from housing developers. Alright, so there are 2 types of statutory sale and purchase agreement. The first is the sell then build concept, which is within Regulation 11.1 of HDR, providing that the contract of sale and purchase of land is in the form prescribed in Schedule G. So here, generally, that during the launch or sale, the property is under construction, and then the developer would rely on the purchase price from the purchasers to complete it. And then the second type is build and sell concept, which, as it is called, the property is completed first and then it is sold. So in application to our case, since Lot 234 was decided to be purchased by Ali Hadi when he attended the launching at the developer's site office, hence Regulation 11.1 of HDR in the form prescribed in Schedule G will be applicable, and the type of statutory sale and purchase agreement is sell then build concept. Alright, so the process to transfer under the HDA has several requirements, which includes the preparation of agreement and necessary instruments, signing or attestation by witness of the documents and instruments, the adjudication, the payment of stamp duty ad valorem, the issuance of stamp certificate, the presentation or registration of Form 40A, and the issuance of the new issue of document of title, IDT, in the purchaser's name. So, it has been noted in the facts of the question that the individual title to Lot 334 has been issued and established in Schedule G. The salient provisions within the HDA for Schedule G in regards to property purchased direct from developer with title available includes, firstly, the status of the title in the preamble. So here, the developers must ensure all titles are free from encumbrances. So the developer in this case has created a bridging loan with SMB, bridging loans are usually created for developers to begin construction, which as security, they charge all titles to the bridging financier. So here, the information of the bridging loan must be stated in the preamble. Secondly, the purchase price and the schedule of payments, which are within the clauses 4, 5, and the third schedule of Schedule G is also provided. So here in the third schedule, it is prescribed that the purchaser, which in this case is Ali Hadi, he is to pay the purchase price by installments, and he can also pay by installments according to the completed stages of work. Moving on, Clause 6 of Schedule J also provide financial facility. Here it provides that Ali Hadi can apply to any bank for a loan to pay the balance of the purchase price, of which the bank, in this case Ali Hadi will be applying to MTB, will release the loan according to what is written in the third schedule, that is stage by stage. And then there's also the process of sale and purchase transaction within Schedule G. So here, Ali Hadi, as the purchaser, he must first pay the 10% purchase price, as stated in the third schedule of payment, and then the solicitors will then open a file and record in the registration book. And then they will prepare necessary documents, such as including, but not limited to, the building plan, layout plan, etc. Fourthly, Ali Hadi must sign 4 copies of the SPA, 2 copies of Form 14A, and pay the legal fee and disbursements. And then forward all the SPAs and other documents to the developer to sign. And after both parties have signed the documents, having the documents witnessed, the solicitors will stamp all 4 copies of the SPA, of which the nominal duty costs 10 ringgit each. And after stamping, the solicitors will forward a copy to the developer, the original, and a copy to Ali Hadi as the purchaser, and 1 copy of each document for filing. And during this stage, if loan is needed, it is advisable for Ali Hadi as the purchaser to apply for loan. Is the adjudication that can be performed online. It is a valuation process done at Pejabat Penilaian, LHDN, to get a market value for the property, this being the Lot 334. So the calculation of stamp duty ad valorem on transfer will be based on a certain value, that is either the purchase price stated in the SPA or the market value that will be taken of whichever is higher. So the formula for calculation will be referred to in item 32 of the first schedule of the Stamp Duty Act 1949. And then the solicitor will pay the stamp duty ad valorem either by way of online or in favor of timbalan pemungut duty stamp. And after payment has been done, the solicitor will receive a stamp certificate, and afterwards, on presentation day, Ali Hadi's solicitor, as the purchaser's solicitor, will present the Form 14A and the original issue document of title, or the IDT, for registration as embedded in Section 2061 of the NLC, the National Land Code. And subsequently, the balance purchase price will be paid to the developer according to the schedule of payment that has been stated in the third schedule of the SPA. And in regards to the collection of original title, about a month later, which is the approximation, in accordance to the land officer's discretion, Ali Hadi's solicitor, as the purchaser's solicitor, will collect the original IDT, which has been duly registered in the name of Ali Hadi, which in this case, as a purchaser, from the land office. And since Ali Hadi will be applying for a loan, the bank will hold the original IDT until the loan has been fully paid, of which a copy of the IDT will be given to Ali Hadi and keep a copy for file. And finally, in regards to the closing file, the preparation of document for transfer under the HDA will approximately be within 2 to 3 months. The construction of houses will continue according to the allotted time frame, which under Schedule G must be completed within 24 months from the date of the SPA. Alright, so before it's truly complete, there's another matter, which is the bridging loan matter. So the fact provides that the individual title is currently charged to SMB as a security for the loan granted by SMB to the developer. And since the developer had made a bridging loan with SMB, the process of transfer of Lot 334 includes the redemption process under the HDA. And a bridging loan is generally a short-term loan that was applied by the developer to meet their obligations and costs to begin construction. So then the bridging loan is paid through a redemption process. So an arrangement can be made by the developer and SMB as the bank on how purchasers of the properties will redeem their house from the bank from the charge created. And since individual title to Lot 334 has been issued, the process of redemption includes SMB issuing a redemption statement to the purchaser, which in this case is Ali Hadi, to Lot 334, requesting him to pay and redeem Lot 334. So since Ali Hadi is applying for a loan from MTB as the financier, SMB will issue a redemption statement to MTB as the end financier, and MTB will make payment of the redemption sum to SMB. So the content of the redemption statement consists of the statement of the total redemption sum to be paid, and then SMB undertakes that upon receipt of the payment of the redemption sum from Ali Hadi's bank, and that is MTB, the charge of Ali Hadi's Lot 334 will be discharged. SMB has no more interest or claims whatsoever to the property, and SMB will sign Form 16N, which is the discharge of charge form, and forward it with the original title and the duplicate charge to Ali Hadi's bank, and that is MTB. And by having the original title, the MTB can register the charge.
Thank you so much to Miss Adlyn, and also Miss Syahaneem is being very helpful to me, because I think I finally can understand and can see the steps and flow to buy this house and about the title and so on. I will proceed to bank and to discuss further about this to buy this house. Thank you so much.